Matter before the court today, except for a hearing on the motion of the intervening parties. I would tell you that we had in this matter written out Taylor Morgan for today's proceeding. We received confirmation from the prison that they would have her available. We've been in contact with the prison now for about 40 minutes back and forth. They're saying they're having difficulties with their Polycom system and they can't apparently get it to work. So they can't get her to appear because their system is not working at the current time. They said they're trying to fix it, but again, that's been 40 minutes that we've been on the phone to MDOC with multiple individuals and really no answer as to when that might occur. We'll proceed. Ms. Reed, you had filed a ex parte motion. I will tell you, just so the attorneys know, I really don't like ex parte motions, but I understand with the short notice that you had to file something. So I'll let you proceed with that before we proceed.
All right, thank you, Your Honor. Yes, we filed an ex parte motion to adjourn and for a scheduling order because there's some Michigan court rules regarding service and notice that I believe have not been followed, and it prejudices my client and our ability to prepare for the hearing today. So regarding the Michigan court rules, Mr. Bartell was ordered to prepare an order under the 7-day rule at the hearing on 7/22 for the show cause that was not prepared, not issued, not entered. Then there was a frivolous order to show cause, again, filed by Mr. Bartell on 8/8. We never received a copy of that. That was denied, and it was clearly frivolous because it requested an order to show cause for denial of grandparenting time when grandparenting time order was already vacated. I never received a copy of that, was never noticed it, and we had to request certified copies from the court to get that order. And then again on 8/8, another motion to show cause was filed that I have not received or been served with. And then on 7/31, Mr. Bartell signed a subpoena to Grace Health requesting records. And under MCR 2.305A5, a subpoena to a non-party for deposition of records is required to be served on all parties on the day that it was issued. And we did not get that until a week later. I had to do due diligence and call Grace Health to see if those records had already been furnished before I could even file or try to file any protective orders in that matter. So that prejudiced us in trying to protect those records, finding out if those records had already been done because we were not served properly. The proof of service for that subpoena was not filled out properly, and no proofs of service for any subpoenas have been filed with the court before this hearing, which is a violation of the court rules. And then I was made aware that witness subpoenas had been issued. I was not given copies of those subpoenas, and I understand that Mr. Bartell's argument is that he does not have to give me copies of those subpoenas. And while that might be true, the subpoenas on the MC-11 form for the subpoenas that were required to fill out the proof of service very clearly states that that subpoena must be served and a proof of service for that subpoena filed with the court. Filing that proof of service gives me notice of the witnesses that he intends to call. And the due process of the Michigan court rules, case law, discovery, trial preparation is also that we do not have these hearings by surprise. And in this case, we are dealing with a constitutionally protected right of a parent, and I do not have any sort of notice of any other witnesses that Mr. Bartell intends to call. So we are requesting an adjournment, and I believe an adjournment is appropriate because I do believe mom has a right to be at this hearing, and now she cannot be at this hearing, and for a case scheduling order with witness disclosures so I can have an opportunity to adequately prepare a cross-examination with my client.
Okay, thank you. Mr. Bartell, any response?
Yes, Your Honor. Unfortunately, I think that counsel on the other side is misrepresented, not only facts and law to this court. And I'm a little dismayed by that, quite frankly. I will admit that my staff did not send out immediately the one subpoena to Grace Health. When I inquired to my staff she said, I'm sorry, Aaron, I didn't, and she immediately sent it over to Miss Reed. It's interesting that Miss Reed comes in here and says, well, I didn't have time. She had another week beyond then to file an objection. And usually how it's done is you make contact with that particular organization and say, I'm objecting to this, hold off until the court decides. You file your motion, file whatever you need for a protective order. Didn't do any of that. I highly doubt that they were going to file something since they still had 7 days, Your Honor, and they didn't do it. Further, I do not have to, under the court rules or the law, and I would love a court rule or a case from Miss Reed that says I have to serve on her subpoenas for a witness to appear to a trial or an evidentiary hearing. I have never done that. I have never seen an attorney do that ever, except Miss Reed. I've been doing this for 13 years, unless every other attorney I've dealt with is in violation of law too, but she still doesn't provide a court rule. She says some vague thing regarding the subpoena. I do not have a duty to provide her a copy as to who I'm subpoenaing to be here. Number 3, Your Honor, with regards to the production of documents, I usually, as a matter of course, actually do provide whatever I receive from whoever I'm subpoenaing those documents. I provide to the other party. I would like to direct attention to MCR 2.305A7. It says, upon written request from another party, so they're the other party, and payment of reasonable copying costs, the subpoenaing party shall provide copies of documents received pursuant to a subpoena. That is actually the rule. I don't have to provide it to her. I do it as a matter of course, and I did provide it to her. She just didn't like how it was provided to her. We sent it out via mail because we received an email, but via a secured system with Grace Health. I don't have some secured system to provide to her. She never said, Aaron, can I come pick those up then? I would like to get them quicker. She could have done that. We had indicated that we had mailed it out the day before when she inquired about it. Pursuant to the court rule, I didn't have to provide it to her. That's why it's a misrepresentation, and I'm a little, not happy about this because she's misrepresenting court rules and law to Your Honor. Yes, the whole point of giving the other side notice as to receiving documents or other information from a third party is that it gives them the opportunity to object if they think that it's improper because it's privileged information or something like that. And she had ample time to object. She didn't object, Your Honor. With regards to the order that was not entered, that was not entered, but the Court of Appeals did already reverse. So I'm not entering an order that the Court of Appeals already reversed only on that matter. With regards to show causes are filed, and we just had one come back in the mail in which we had filed a show cause, and the court had denied it, I think based upon the Court of Appeals decision. We have sent over the denial to Ms. Reed. This is just ridiculous, Your Honor. I don't appreciate attorneys coming in and not signing the appropriate court rules or reading the court rules, and it's as clear as day, read them. We did comply with the court rules, except for, I will admit, we did send out a week late, and I apologize for that. But I think it's a moot issue, given that Ms. Reed did not even object or attempt to do anything, except she now wants to come into the court and complain to you. So I'm actually asking for costs for having to read this ex parte motion because there was factual inaccuracies and she misrepresented the law, Your Honor. That is not right.
Okay, thank you. Anything
I
else,
respond, Your Honor?
Ms. Reed?
There was no misrepresentations. As soon as I got that subpoena, I immediately called Grace Health and was starting to leave messages because it does not make sense for me to file objections when the documents have already been produced. That would be a frivolous objection saying, hold on, no, Grace Health, don't send that if I don't know if Mr. Bartel's already gotten the documents. That doesn't make sense. It just doesn't. I'm going to file an objection saying, no, hold on, don't file these documents. I want to wait for the court. when they've already been received. That's why I was making phone calls as soon as I got that late subpoena to try and see if I could file an objection. And I contacted the HR or the subpoena compliance director over at Grace Health, who gave me the information that the documents were sent via email to Mr. Bartel and when they were sent. And by that time, and when I actually found all the information, it was already done. I can't do anything about that. Now, granted, I should have been immediately served with that subpoena. I should have been. And while Mr. Bartel says, he does not have to serve me subpoenas, he does not. What he does have to do is file those proofs of service so I have notice. And the Michigan Court of Appeals has upheld trial court decisions to strike witness subpoenas when there was no notice to the other side based on unfair surprise. And that's what these witness subpoenas are. It's unfair surprise. It's a trial by ambush. If I don't know that these witnesses are going to be appearing, if I don't know that they're going to be testifying, what they're going to be testifying about, who they are, and I won't have adequate time to talk to my client to prepare. And there's unpublished case law that does this, that says that there's an unfair surprise. There's published case law that says that there are no secret subpoenas to be issued, that the other side is entitled to notice about subpoenas and witnesses.
Your Honor, can I respond? Because once again, we don't have a good timeline here. Paragraph 14 of the ex parte motion. Petitioner's counsel did not provide a copy of the subpoena to plaintiff's counsel until August 7th, 2024. We just heard from counsel say again, I didn't have time to do anything. That's inaccurate. She said that supposedly Grace Health sent it over to us on August 12th, 5 days later, Your Honor. That is factually inaccurate. And she's still misrepresenting to the court. That is what gets me going on this. And so what in those 5 days did Ms. Reed do? She did nothing. Or she had a conversation and now she's still misrepresenting more to the court. Further, she keeps talking about unpublished cases. There's nothing in here. She had one case, it was a criminal case that said reference a stealth docket. I was doing some research. It was copy and pasted from some note in the court rule book or ICL that said that. Well, if you actually pull that case up, it is referring to when you are subpoenaing for information documents. And that is correct. We don't want someone to gain all this information that we don't know what they're seeking from documents. That has nothing to do with subpoenaing someone to appear and attend, Your Honor. Because guess what? She has the ability to cross-examine those witnesses. That is the purpose. Okay. That it's just mind-boggling. She still can't cite any court rule or case law.
Okay, thank you. Well, obviously, in this case, it's now approximately 9:15. Matter was set for 9:30, and we still have not gotten communication with MDOC as it relates to Taylor Morgan and her attendance in this matter.
Yes, we did receive, I guess. They say that she can appear by telephone, but I have nobody here yet.
Okay, so we still have no contact there, so.
Yes.
In this matter, the court does note that the subpoena issued to Grace Health that apparently, as Mr. Bartel acknowledges, that his office didn't send it out to Ms. Reed for about a week. It was an oversight. And the court will not ascribe any improper motive to Mr. Bartel for that notice, but the court does note that Michigan Court Rule 2.305(a)(5) does provide that a copy of subpoena must be served on all other parties on the date of issuance. All I can think of is I will tell you the United States Postal Service is far less efficient than it used to be, and mail sometimes travels at a snail pace. But the court would note that the court rules were adopted to provide fundamental fairness to all the parties involved in the litigation. And I understand that with this matter coming up, that petitioners may have been against the clock in preparation for their case as well. So you don't always have all the time that you need to get subpoenas and respond and things of that nature. But the court does also believe that each of the parties are entitled to sufficient time to prepare their case and their defenses in the matter. And again, because of the fact that Ms. Morgan, Taylor Morgan, is not able to be present, and is not present now at this particular point. The court unfortunately is left with the difficulty in this matter of whether to proceed. And as Ms. Reed, I don't know if she's received the documents from Grace Health yet in this case, but she hadn't when she filed that motion. And I think she's entitled to those documents to be able to know what's in them, because if she's going to effectively cross-examine, she needs to have them. As a result, the court is going to grant the motion to adjourn. And what we will do is be in touch with the attorneys to see when they're available. We don't have to appear next time in person as happened at this particular occasion, because obviously Ms. Reed isn't, we have Taylor Morgan can't. And so I think probably better and easier for all of the witnesses if they're able to appear vis-a-vis Zoom as well. So the court will do that. I am going to, so that there are no issues and no surprises, I'm going to order that the parties would, within 10 days of today's date, disclose all the names of their potential witnesses in this matter. Ms. Reed, you can prepare an order adjourning the matter and also stating that the witnesses will be disclosed within 10 days of today's date. With that, Ms. Reed, is there anything else further?
Do we have a date, or is it going to be a date later set by the court?
There'll be a date later set. I'm going to have to call both of the offices and see when both of you are available and when we're available.
Are there any witnesses in the lobby or Zoom?
Yes, I have Deborah Arnold, Kelsey Cronkite.
Okay, can we bring them in and dismiss them?
You want me to bring all of them in? Do you have also an Allison Martha? Is that one of yours?
Okay,
Are those your witnesses, Ms. Reed?
yes.
We'll
I
let
think
you-
Kelsey Cronkite was under subpoena.
Okay, you can contact your witnesses and release them, and Mr. Bartel will do the same. Anything else, Mr. Bartel?
Yeah, I understand how the court ruled, but and I was just listening to what the court had said. I just want to make sure the record is clear. The court had indicated that cross-examination by Ms. Reed, she's actually the one who's subpoenaed, and it's her witness is the counselor. So it's not a cross-examination. So we were talking about preparation. It was her witness,
Okay,
actually. That's number one. But number two, I just want to make sure that 2.3057 says I actually don't have to provide those documents to her. I just want a clear record. I respect the court's decision.
I'm not saying that you have to. I'm saying that she has a right to get those.
But she didn't get them, Your Honor, is all I'm saying. I get
I
it.
understand. But she wanted those, and I think you had sent them, so she's gonna get them eventually as soon as the post office will get the mail to her, so she'll have them.
Well, I don't know if she got them or not. She never indicated that to the court. She didn't say.
Well, just for clarification, Ms. Reed, have you gotten those yet, or?
We did get them this week.
Okay, thank you.
So
Well, just prepare the order, submit under 7-day, and again, we're stymied somewhat because of the fact that Taylor Morgan is not able to be present. And
well, I'm willing to proceed forward and have her appear at a later time if that's an issue for the court.
well, no, we will adjourn because as a party, just her appearing at a later date isn't going to help us, today's date if we can't get her on. Miss Taylor Morgan is what I'm speaking about.
I understand. I was just suggesting that she can testify on a later day. We've.
Not concerned about her testimony. As a party to the case, she has a right to be here when everybody else testifies.
Well, I understand. I represent her too on that, Your Honor.
Okay.
And I have a waiver of conflict of interest between the grandparent and her.
Okay.
So I just want to make that clear, is that there's a waiver of conflict of interest between that two, and as her counsel.
Bartel, just for clarity, when I reviewed the file, I didn't find any appearance on your behalf for Miss Taylor Morgan.
Well, not for, I guess, this particular hearing, I guess, if the court wants me to enter one, I can do that. I had just filed a motion for order to show cause that I'm waiting for the court if it's gonna sign.
If you would, just to clarify and basically get the file in order, if you would do an appearance for her as well, and then that way we may not have some of the issues with MDOC that we're having today if you are representing her.
Okay, I don't know how that would clear the issues up, but I'll do that, Your Honor.
Well, we had, not aware, because you didn't have an appearance, not aware that you had represented her. We had her written out so that she could be present for this hearing as a party to the case.
Okay.
Well, if you're representing her, then we may not have those particular issues. Do you want us to still writ her out for the next hearing?
Well, yes, I mean, in my experience, usually the court is gonna writ the person out even. Maybe not always, but usually the court is gonna writ that person out because they have the, I think, better ability than counsel, even if they represent them.
That's why I'm asking.
Yeah, I would like that, Your
Okay.
Honor. Yes, thank you.
We will do that, and at this point, we'll stand and recess, adjournment.
All rise.
Good morning, Your Honor.
Good morning, Your Honor.
This is the time and place set for the evidentiary hearing on the intervener's motion for grandparenting time. And Mr. Bartel, are you ready to proceed?
Yes, I am, Your Honor.
Miss Reed?
Yes, I am, Your Honor.
Okay. Mr. Bartel, are there any preliminary matters before we commence?
The only thing I would indicate, at least on my end, Your Honor, I have Dr. Haugen. He's not able to appear today. I don't know how long testimony will take. So I would ask that, and as this court knows, he's testified in this court many times before. He has conflicts at times. He can appear for October 1st. So I would just like to make note of that in case we have to go out of order.
Okay. Ms. Reed, is there any problem with taking Dr. Haugen out of order?
There's not a problem with taking Dr. Haugen out of order, but I would object to Dr. Haugen testifying as a witness since he has not examined this child. There's been no psychological assessments of this child by Dr. Haugen. He hasn't met this child, so any testimony would be pure speculation.
Okay, well, what we'll do is, obviously, as you have no trouble taking him out of order, then we'll address that at the time that Dr. Haugen's going to testify. You can raise the objection at that time. I'm just making note. Anything that you have, Ms. Reed, preliminarily before we commence?
Preliminarily, I have the motion for summary disposition that we filed. And then I also wanted to do a motion in limine to have Mr. Bartel make a specific offer of proof regarding the relevant testimony of these 17 witnesses on his witness list. Again, it's our opinion that none of these witnesses have had any contact with the parties, my clients, or this child in almost a year now. So how are they going to be able to testify of firsthand knowledge of substantial risk of harm to this child or in the best interest of this child when they have not had contact with her?
Okay, well, court's not going to, I guess you'd say, prematurely determine what the witnesses may or may not testify to, or what the basis for their testimony may be. As we get to each witness, we can address that. But again, to do otherwise, the court would be basically looking at and total conjecture as to what they may testify. I don't know what they've seen or what they have not seen, et cetera. So at this point, I'm going to deny your motion in limine, and I'm not going to require Mr. Bartel to give an offer of proof as to any of the particular witnesses. He can call the witnesses as you normally would call them. Ms. Reed, if you want to go ahead with your motion for summary disposition, you can go ahead.
I'm not going to repeat everything contained in the motion, as I'm sure the court has read it, and I've read Mr. Bartel's response. But the basics is, even if all the claims in the motion are true, for argument's sake, the grandparents have failed to allege that Ari is an unfit parent. They have failed to allege any substantial risk of harm to the child's mental, physical, or emotional well-being created by Ari's decision to deny grandparenting time. And as a matter of law, they cannot rebut that or overcome the presumption. That's again in their own motion. They only say that they only use the word detriment or detrimental, and that is not the correct or required legal standard, nor is it a detriment or detrimental to the child to deny grandparenting time when the child does not want to see the grandparents. She's old enough to state her preference. I believe the court interviewed the child in this matter. And if she's any way consistent with what she's repeatedly told my client. She probably informed the court she does not want to see the grandparents. So now the grandparents are trying to claim that there is a substantial risk of harm and we just don't see it. And I don't see how they can claim a substantial risk of harm when they waited 6 months after they had not seen this child to file this motion. If there was a substantial risk of harm to this child, they would have filed it immediately in November when that contact was stopped. Further, like I had just previously said, none of these witnesses have seen or had significant contact with the child in almost a year now. The grandparents haven't had contact with the child in almost a year now, so they have no firsthand knowledge about her mental, emotional, or physical well-being. They are also out of touch with this child. They don't even know that she can write. They don't know how she's doing in school. And the Court of Appeals had already reviewed the motion and the affidavit and our response and had determined that the record does not reveal that there was deference given to the plaintiff's decision to deny grandparenting time, or that the grandparents rebutted that presumption. And they've already reviewed everything that we believe that they can offer. So what additional information can they provide to the court when they have not seen this child in this long to rebut that presumption? They just can't. There hasn't been any harm done to the child. There's no risk of harm being done to the child as a result of the denial of grandparenting time. But there has been harm done to the child through mental and emotional abuse by the grandparents telling the child that Ari is not her father, taking a scorched earth approach to impose their will on this 6-year-old when she does not want to go, causing immense financial harm and strain to my client having to litigate this to defend his constitutional right as a parent and protect the child's wishes and desires from being forced into time and a relationship with someone she does not want. Grandparents have established immense hostility towards my client via efforts trying to force grandparenting time, trying to find him in contempt, blasting him all over Facebook, calling him disgusting and that he's sick, and telling this child to conceal and lie to her father that he's not the father, which is greatly upsetting to this child, and that impacts their own moral fitness. So in all, it's clear that Ari has a constitutionally protected right to make decisions about the care, custody, and management of his child. And that also includes who the child sees and does not see. And the court recognizes the presumption that a fit parent will act in the best interest of their child. They cannot rebut the presumption. Their motion doesn't even mention the presumption or any indication that they can. Now, I have read Mr. Bartel's response, and he kind of alludes that I asked for a adjournment for maybe improper means to file a motion for summary disposition, and that's not true. I had concerns that this was going to be a trial of ambush, and I think my concerns were valid, being that now we have a 17-person witness list, and this was scheduled this late because Mr. Bartel had a scheduling conflict earlier, because I do believe the first date we were given was the 5th of this month. I had the appropriate time, so I believed it was appropriate to file this because we do not believe, and that it has been sufficiently pled on its face, that the facts are supported or that the statutory requirements have been met in the motion itself, or that there can be any evidence to back up that motion for itself. We did ask for an evidentiary hearing in our various pleadings because at that time, the court had already entered the order for grandparenting time, and we believed that the court could not do so without having a hearing regarding the rebuttal of the presumption or the best interest of the child, and I believe the Court of Appeals agreed. So that's why we're not going like back and forth and asking for two separate things. We're saying now the grandparenting time order was entered. That was not correct. We needed to have a hearing if it was going to be the case, but we're now saying they don't even pass step 1 to get the motion to that point of having to be able to present evidence of the best interest of the child, because that's what the statute requires. First, it has to be the rebuttal of the presumption that Ari's decision creates a substantial risk of harm. And then we get into the best interest factors, and their motion falls flat on its face. So we're requesting that this be denied. If the court would not deny their motion outright, we are requesting that the hearing be bifurcated to follow the statutory requirement that first they must rebut that presumption, and then we get into the best interest factors. And it does not, like Mr. Bartell says, it's not interrelated. The statute's pretty clear that first they have to rebut the presumption before they can go any further.
Okay, Mr. Bartell?
Well, I mean, let me start off. There was a lot of facts presented by the other side that clearly warrants this hearing, Your Honor. I mean, when we have plaintiff's counsel just making all these allegations, it's clear that's what she is relying on. The interesting thing here, Your Honor, is, and I did point out, there was it was about 11 or 12 page motion for summary disposition filed in the afternoon after they filed an ex parte motion to adjourn out a hearing, claiming there was trial by ambush, claiming we didn't follow the court rules, but we did, by not having to provide, and I don't have to go through all that, but obviously inaccurately giving this court information as to the law, not candor to the court. And then all of a sudden, the third motion of the week, because the next day after the motion for summary disposition, they file a motion for counseling. It's quite suspect, Your Honor. It became abundantly clear that's what they wanted. But first, their motion for summary judgment is actually really a motion for reconsideration. I say that because they're making exactly the same arguments, Your Honor, as they made in their initial answer to this court. This court already made its determination. There was sufficient evidence to proceed forward to an evidentiary hearing in this matter. But even more importantly, and isn't even addressed by plaintiff in oral argument, is that they requested not just to have an evidentiary hearing with the Court of Appeals. They actually requested multiple things. So now to couch it in the terms of, well, we asked for an evidentiary hearing only because there was a temporary order entered, that makes no sense. Further, the Court of Appeals in its order ordered, Your Honor, there to be an evidentiary hearing. And plaintiff fails to present that or address that with the court. It is very clear that this was an improper motion. If we want to talk about unnecessary delay, if we want to talk about unnecessary cost, perhaps plaintiff and his counsel need to kind of look at all their filings, in which there was, I think, 5 filings within a 2-week period, and further that they're not even following and cherry picking what they want to see, but they're not even following the Court of Appeals directive. Okay? The Court of Appeals overturning this court on the temporary basis has nothing to do with an evidentiary hearing, and actually has nothing to do with the long-term potential order of this court. And to try to mix those two issues together is sloppy at best. So, Your Honor, we have to follow the Court of Appeals. Okay? And it said to go have the evidentiary hearing. And in fact,
Aaron, we lost Judge.
Yeah.
Hold on.
Oh,
Sorry, yeah.
Do you know-
have to.
do you recall when?
Say what?
Do you recall when in my argument?
Maybe the last 30 seconds or 20 seconds. Let me turn on the ring. I lost.
You out, Mr. Bartell, so you can, I guess, restart from where you lost me.
Unfortunately, I don't know where I lost you, Your Honor. So I will try the best where I think I left off. But
Okay.
The long and short of it still, Your Honor, is that the Court of Appeals made a determination in its order. It was a short order, but it actually indicated to actually have the evidentiary hearing. Okay. And plaintiffs don't address that. They clearly don't dispute it. Otherwise, they would have addressed it. And that is why I'm actually asking your honor at a minimum. I mean, I think costs are really warranted here. That is a prime example of a frivolous filing in a court where you already made the determination. Okay. The Court of Appeals had all that information in front of it. And the only thing the Court of Appeals did was just disagreed with your decision on a temporary basis. And further, the order said that go have the evidentiary. I mean, it couldn't be much more clear. You're going to have the evidentiary here. They actually said that. And yet we have Miss Reed, and I should say the plaintiff, filing this motion that we have to answer you on. That is frivolous. Okay. If that's not frivolous, I don't know what is, because you already had two orders. And if they were going to file a motion for reconsideration, they should have followed the court rules, which would have been within 21 days of the order being entered, and they didn't do so. So they're actually coming back still and arguing all the exact same things. I do want to make note of one other thing. I keep hearing about now it's about a year. The months keep on, 1 week turns into 2 months for them. It has not been a year. But regardless, MCL 722.27B1F provides that grandparents can even petition in the year preceding the commencement of an action under subsection 3 for grandparenting time. If the grandparent provided an established custodial environment for the child, whether or not the grandparent had custody under a court order. We had alleged in our motion that there was continuous and constant contact. It wasn't sporadic. It wasn't just a day here or there. It was on a routine, weekly basis that my clients saw this child and that they had this close bonded connection that was established. So every time I hear plaintiff keeps saying about this whole period of time, the legislature clearly understood when it enacted these statutes that there may be a time period in between. And furthermore, if plaintiff would have looked at some cases out there, there are times in which there was a significant gap, not just a month or two. Okay. Furthermore, there have been cases out there in which evidentiary hearings were held over 3-4 day period, over a long period of time, in which the grandparents had not seen the minor child, and yet the trial court gave grandparenting time, and further, the Court of Appeals has affirmed such decisions. So this whole hasn't seen the child, all this stuff, so they don't know schoolwork and all this other stuff. That is not the law. I would submit to the court based upon the decisions out there. To circle back, I really do think sanctions are appropriate, Your Honor. I really do. We had to waste time to answer a motion that was clearly decided 2 times, filed on the same day after they wanted the evidentiary hearing adjourned for their benefit. There's no trial by ambush just because we filed the court orders as to whether or not there's trial, witness lists or exhibits, etc. We filed the court rules except for that one subpoena that got out late, providing to opposing counsel. We filed the court rules in terms of providing the information as required by the court rules. So I would ask for sanctions, attorneys' fees and costs, and having to answer this frivolous motion. The second part, Your Honor, is the bifurcation issue. That is hard, as I indicated, to try to bifurcate the best interest factors with the rebuttable presumption that there's a substantial risk of harm to the minor child's mental, psychological, or physical well-being is hard to parse through. Further, as I had noted before, and counsel was agreeable that Dr. Haugen can testify at I think it's October 1st date, he is part of that rebutting of the presumption, notwithstanding the presentation by plaintiff that he has nothing to add because he's never seen the child. Once again, there are plenty of court appeals decisions where they have psychologists, not a social worker, testify as to generalities in which trial courts have, our trial court can actually take that testimony as information with regards to the particular matter. So I would ask for us just to proceed forward and present our case with all the witnesses. This court has the ability to parse through all of that information and issue the decision that this court deems reasonable.
Okay, thank you. Ms. Reed, anything else?
Disagree that this is a frivolous motion or that it was filed frivolously. We follow the court rules regarding motions for summary disposition. This is not a motion for reconsideration. It's basically on the motion itself fails to plead sufficient facts.
Okay,
And so it should be dismissed outright. And the Court of Appeals specifically found that the record does not meet their requirements either for a temporary order. So we're asking again for it to be dismissed.
okay, thank you. Well, the court notes that this motion is filed under 2.116 C(H), stating that the opposing party has failed to state a claim upon which relief can be granted. In this case, as the attorneys know, that a C8 motion tests the legal sufficiency of the claim based on the factual allegations in the complaint. The trial court must accept all factual allegations as true in deciding the motion on the pleadings alone. And a C8 motion may only be granted when the claim is so clearly unenforceable that no factual development possibly justify the recovery. I would take umbrage with Ms. Reed's rendition of the Court of Appeals decision, as the Court of Appeals in this particular matter stated that on the temporary basis that the court had not considered the fit parent presumption, not that it didn't exist or that it had some way was not able to be established in this particular matter. So notwithstanding the court having taken that into consideration, the court unfortunately didn't mention the magic words when I made my ruling, and therefore the Court of Appeals again, I guess, inferred or presumed that it had not been considered. In this particular matter, when the court does look at the motion for grandparenting time and looks at those allegations, the interveners had substantial paragraphs addressing the contact with the child and how substantial it is. Now, looking at specifically, court looks at paragraph 27. Paragraph 27 says that on March 1, 2021, plaintiff father's wife showed up at the petitioner's doorstep with Chloe, and she told petitioners that plaintiff father and his wife would let petitioner see Chloe since it was extremely important for Chloe's mental health for such connection to remain. Further, it's stated in the complaint that, again, at that point when the intervener was watching Chloe, that she, in fact, quit her job so that she could do that. And paragraph 42 says, even some of plaintiff father's own family believes it would be in the best interest of Chloe for the paternal grandparents to have, or maternal grandparents to have parenting time with Chloe, and that to order otherwise would be detrimental to the minor child. Then the intervener, Carlina Torlido, said in paragraph 9 of her affidavit, which was in support of her motion, says to not let grandparenting time would be to the detriment of Chloe's mental, physical, and emotional health. Paragraph 10, she says, Chloe loves us, and my understanding is that she has been told that we do not love her. However, when Chloe was told recently that myself and my husband love and miss her, Chloe was excited in case she loves and misses us as well. Paragraph 11 of the affidavit says, I have heard from individuals that still see the father and Chloe that they have told me that Chloe is depressed and misses my husband and myself. Paragraph 14, when Chloe would go home from my residence, when I would not receive routine time with Chloe up until the end of December 2023, Chloe would be very depressed. However, Chloe would be so happy that she would come back to my residence. In this matter, the court, in a motion for summary disposition, has to look at the motion in the context that the court will look at it and give the benefit in the motions to the non-moving party. And when I do that in context of the recitation that I just did, as well as looking at the entire motion and the affidavit in this matter, the court does not believe that, as asserted by plaintiff, that the interveners have failed to set forth a valid claim in this matter. The court will deny the motion for summary disposition. With that, Mr. Bartel, do you wish to make an opening statement, reserve your opening statement, or and proceed with proofs?
Just a real brief one, Your Honor. In this manner, I think the proofs are going to show that there has been significant contacts with the grandparents. I think the proofs will also show that there has been kind of a up and down relationship, so to speak, between plaintiff, his current wife, Kelsey Cronkite, and the grandparents, maternal grandparents. Our position is that this rockiness is not from the grandparents. The grandparents actually, believe it or not, care for plaintiff still after all this. And they want nothing but everyone to come together. They actually think it'd be in the best interest of this child to not, unfortunately, always be put in the middle. And I think the history will also show, if we're going to go back, that plaintiff father, whether that's him, whether or not he is being, I don't want to say controlled, but our fear is that his wife controls everything that's going on, is that we're put in this situation where the minor child has been put in the middle and used as a pawn. Unfortunately, there have been times where plaintiff has allowed the grandparents to see the minor child and then he would yank them away. But I would submit, I think the proofs are going to show, as of most recent, up until the time, which is about the beginning of December of 2023, that plaintiff took the minor child from the grandparents and would not let them see the minor child anymore. Okay. And the proofs are going to show that the plaintiff has taken significant steps, including making unilateral decisions when there's joint legal custody, I think, to better his position. Unfortunately, what we're here still on is Chloe, what's in her best interests. I think the proofs are going to show that the grandparents aren't here to take away the minor child from plaintiff whatsoever. It's just that they had extensive ties to this minor child since the child was born. And those ties, I think, should continue based upon the proofs that are going to be presented, including the testimony that you'll hear from Dr. Haugen, who's a psychologist, that he'll be able to walk the court through as to the harms to the minor child since there has been a cutoff of communication, contact, not only actually with the grandparents, but also with the mother, Taylor Morgan, because plaintiff does not allow the minor child to engage by phone or otherwise with Taylor Morgan. So this is where we're at, Your Honors. There's been a total cutoff of the minor child being able to have communication with her mother, grandparents, and everyone on that side of the family. And I think the proofs will show there is a substantial risk of harm to the minor child's emotional, psychological, well-being in this matter. Thank you.
Okay, thank you. Ms. Reed, do you wish to make an opening statement, reserve your opening statement, or waive your opening statement?
I'm just gonna rely on our motion for summary disposition as it restates our position. And that we believe that the testimony will not show any substantial risk of harm to this child, that she has not been harmed in any way. There's no risk of harm. Any harm that has occurred is as a result of the grandparents' own actions in false information that they're telling this child about their father, and that is the reason why grandparenting time is being denied, and that it would be a risk of harm to or a harm to this child to force her to go for grandparenting time and do something that she does not want to do.
Okay, thank you.